Hello, my lovelies. Guess who's back? All right, let's get into it. Our favorite, non-favorite criminal, Sarah Boone, has entered the chat. And so we're going to look at her hearing. Last time we saw her was on Monday. She had some motions. She delivered some more motions, hand delivered them in the court. So let's check out the judge reviewing those motions today on August 9th. We're going to watch court TV, and I'm going to talk because I'm going to be giving commentary. I'm going to be giving my 2 cents, both of them. And if you want to hear it without talking, you have to just go to court TV because I'm reacting over here. All right. Let's see. Where are we? All right. Here we go. We got Sarah Ann. We got our favorite girl, Bailiff. I think this is the one that has the glasses like, oh, you know what? Real fast. I have seen a little bit of this. I was watching some of it on Brandy Churchwell's channel this morning, the 13th juror. I might have seen some of you guys in the chat. Hey, I had to go to physical therapy though, so I haven't seen all of it. I know she got some wins, she got some losses. So, okay, now let us get into it.
Dave Ketcher on behalf of the state.
William J. for the state.
Ma'am, good morning. Can you raise your right hand? Madam Clerk will swear you in.
You swear or affirm that the testimony you give shall be the truth, so help you God. Yes.
All right, ma'am, good morning, rather. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Okay, we
had a hearing this Monday on August the 5th. The court had entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right. I know that you had brought up concerns regarding mailing, and I just wanted to go through the historics with regard to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Cushman's motion to withdraw and addressed your forfeiture alternative.
Before we go into that, I'm going to read to you really quickly. I'm not going to read the whole motion, but just what they were about. So she had one motion for defendant's immediate address correction. She had another motion, formal address correction. Then she had motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. She doesn't say equally to whom, but I'm assuming it's the prosecution. And she says a lot of words with not a lot of clarity. I find it interesting. Motion for defendant to lawfully receive, review, utilize the original hard copy discovery 2 boxes A, B, submitted to the court by former attorney on June 28th for preparation of trial in her criminal case. Okay, so let's get back to what the judge is about to tell her. I feel like he's about to school her on something.
A waiver to counsel.
This is my dog Checkers. She's 21, and I owe it all to the...
Okay, we gotta wait for Checkers to pass by here. Actually, I'm gonna mute it this way so I can hear it. Hopefully I remember to unmute it. Oh, good Lord. What just happened? Okay, we're back. Or are we? I'm doing too much. Sorry, guys.
Thereafter, there was an order setting hearing that was entered on July 29. That letter, or that order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day. On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you had placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department.
I want to see her face.
And there was also a certificate of service providing you the Justice Administrative Commission's response to motion seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August the 1st, 2024, and mailed to you with address to you, your inmate number, FDC Dorm B.
And it was
PO Box
emailed to Lane. Remember, we read that.
4970, I apologize. PO Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
I did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th.
Correct.
Okay. The next was a notice of delivery of digital copies of documents that was e-filed by your former attorney, Patricia Cashman, on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st. And that was mailed to you at the same address. We've been addressing PO Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was that for?
Notice of delivery of digital copies of documents, which reflected
In the
the
mail.
deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5 different documents, so
Okay.
for receipt.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on May.
Now, why wouldn't she have started going through those? Especially because the ones from Cashman, the last one he said would have come in the mail. It's not part of everything that Billy Lane dropped off, right? There was one that came in the mail from Cashman, and the certificate of service came in the mail from Cashman. Those are the last things from the court docket that you and I read together. So let's just figure out what has she read, since she was like, it's a big stack of papers or a big stack of, and she's wanting the 2 boxes. You think whatever you got before was a big stack. Listen, sis, it's coming in.
August the 5th. It was provided to you on August the 5th at the PO Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just
Okay.
a moment, yeah. So
After
I know
we
that there
get
was a
to
concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those
he
3
just
documents, without knowing specifically which ones they are, those were also sent to PO Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's
No.
not correct.
They have
Court
records.
scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can't tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was
I would say it must be, as she said, big of a deal to her because she's still coming back, right? So if it's important to you, why didn't you come with your receipts and say, here are these 3 documents. Here's the envelope that clearly shows it was sent to the wrong place. So I'm going to believe the judge when he says they looked at the file and it was only one.
the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Yeah, Mr. Lane, get yourself up there, sir.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, owner of Prison Break Investigation.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So,
The digital evidence.
Yes, Your Honor, we have tendered to Mr. Lane
Like the video?
a copy of our, the exhibit list with our expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file that in open court.
That was going to be my next question.
And I
Okay.
have a
And-
copy for defense.
Okay,
Thank
very good.
God. So we don't have to hear her ask,
Um,
can I have a copy? Can somebody make me a
Bruce, if we
copy?
can get the copy of the witness list and the exhibits.
Use
and
the
take that
copy
from Mr. Lane and
machine
provide it to Ms.
where you
Boone.
posted my poster about needing an attorney, that one.
Yes. And Your Honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way
Not
that
published.
witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before.
You know why? Because we out here
our
being
notice
nosy.
of the exhibit list.
So it'll be one of those things on the docket with a little
What
lock.
I have in
and we
front of
won't
me
be able
is the
to
notice
view
of
it.
provision of witness list and then the notice of expected evidence and witnesses in trial. I don't have an order or.
It wouldn't be an order, it would just be that first document you read, reference, the notice of provisional witness list.
Got it. Okay, thank you. All right.
I'm interested in trying these new weight loss shots.
Oh my goodness. So yeah, it is interesting that she go through whatever paperwork he did. Now remember she was yammering about having hard copies so she could be up at 2:00 in her bunk. So you got those on Monday. It is now Friday. You weren't up every night at 2:00 in your bunk, ma'am? I don't understand. I don't understand. What happened? Yeah, I don't know. I think she's met her match in this judge. I'm so glad this is the judge taking it to trial. No offense to Wooten, but I wonder if he would have got it across the finish line. Because this guy understands exactly who Sarah is and is here to bring all of the foolishness to an end. Rightfully so. Rightfully so.
With regard to the expected evidence and digital evidence.
No,
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
yes.
Okay, all right. And those are all on the USB drive
I
that is
wanna
going
know
to be
what they
provided to
are.
Ms. Boone.
Yes, they're broken down by folders.
And the folders, are the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
Okay, all right.
I don't care what they
State,
renamed
anything
it.
else to add with regard to the digital
It'll
evidence?
always be
No, I
the
also have a
suitcase
copy of the thumb
video.
drive as well as Mr. Lane has had an opportunity to copy for his client that I can tender I can either tender to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right.
So instead of a copy, he's got the original.
Ma'am, or Mr. Castore, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
Maybe she'll let something
I
slip.
don't know what the majority of them are.
That's
Is
not a
this part
question.
of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay.
What-
Any other questions? Yes.
Of course.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you
What?
mean you cannot open a majority?
Yeah,
What can you
what
not open?
percentage? 50?
I don't
One
know specifically which files. I
would be a
know that some
majority.
of them come up as videos, some of them come up as JPEG, some of them come up as different formats. But there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
What does it
Okay.
say?
So I don't
What does
know.
it say?
I don't know. I moved on from that to try to go to other programs. So
Well, what kind
I
of
don't know. I
error
figured it would be
message
something
did it
that I
give
might be
you?
able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now,
Not
that's
to
one of the problems that
Billy.
I'm having with the laptop.
Damn, did
But you
you
said it's a
wake up with
majority.
him?
But you can't identify specifics for me, and that's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
But you said majority, so over half of all
And how
the
many
files
times
you
has that
got,
happened?
you can't open.
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I haven't.
What does that
I have
mean
not
for the
had
most part?
a
I don't know
moment
what for the
to.
most part means.
I haven't had time yet to
50%?
explore everything due
Girl, what
to
you been
the
doing?
dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you. So you know what I'm trying to work on in order for privacy to be had. So
Oh my God.
I haven't explored
Deal with the
both
privacy.
USB drives
Still wanting
to the
paper
fullest
copies.
potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
What? There's no Geek Squad in the jail, girl?
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original
I bet that's
public
George
files
buying the
from
wine.
there, and then we also had those files converted to VLC.
Right,
because
Publix,
they are easier to play in
PUBLIX
VLC. So
restore.
if she clicks on
Ooh, they got
that folder, she can click again on a subfolder, and she will find
You guys
VLC
think you got
files
more than
for
2
where
bottles
the
of wine?
Publix video has been converted. So everything in there should be
Her
standard
interest
JPEG,
isn't even
VLC,
peaked. Publix video?
and
What
also
Publix
leave an
video?
MP4 for some audio only files.
All right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So, Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern
On
that I will not be
Saturday?
able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure, okay. State, anything else we need to talk about with regard to that issue?
I would have asked what format they're
Okay,
in.
all right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About
I wonder if she has headphones. I muted them for a second. Well, let me let them talk and I'll be back.
have further conversations with Major Mohammed at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay.
Of course.
The
she is.
jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property and the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
That's what he just
So
said.
it was
Tracy Hall.
Hall, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a
Hall.
property locker?
Tracy Hall.
Miss Hall.
Okay, all right, thank you. Do you know Ms. Hall's first name?
I don't know any of the officers.
Okay, all right. So in
Oh,
conversations
no.
with Major
Move
Muhammad,
this along.
they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well.
9 a.m. on Saturday?
This one curl is the reason I started.
Oh, good Lord. Okay. Oops, that's not what I wanted to do. If you had every conversation you had, there was a miscommunication, wouldn't you start to question, like, maybe it's me? Right? I just like even at work. Sometimes that's a contradiction. Sometimes I'll ask, like, is it me? Is it, how am I contributing to whatever is happening? And I feel like Sarah never does that. She's just like miscommunication, inferring it's on the other person's behalf that she is miscommunicating and not.
I can't.
Okay, so
He just
I
asked him,
know
"Can you
for
go
a
to the
fact that
jail
Major Muhammad
today?"
is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously. And Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking her hard copies?
No, yeah.
Okay, so for the record then, that
State is
motion
like, hell
will be
no.
granted. The motion for defendant to lawfully receive, review,
Woo!
utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28th, 2024.
I
for
almost feel
preparation of
like
trial
they
in her
shouldn't give it to
criminal
her
case.
because
As ordered, Mr. Lane
now
will deliver those to the jail today.
he's gonna harp on
Seek to have them
everything
delivered
every
to,
time.
Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane, the deposition transcripts of detectives Chelsea Copsall and Scott Lowen were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You had the smaller one, which was everything you digitized from the 2 boxes, and then you had the larger one of other materials that you had been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has the physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Can Mr. Lane be released?
Yes.
Okay. If you want to, can he be released, ma'am?
I guess I'll see you at 9.
Okay. Sir, if you could endeavor to do that today, I would greatly appreciate it.
Absolutely.
All right. Thank you very much, sir.
Thank you.
All right. The next matter this morning is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing.
I was
the courtroom
excited
that's
that she
hand
said
filed
just
court on
now,
August 5,
but I was muted
2024.
because she's learning.
Courts have the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay, so ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay.
Do you have any questions about that process?
I don't.
Okay, all right, let's go ahead and call your witness. State.
State will call Gavin Lowton.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LWTAN.
All right, thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
The prosecutor has on a
To
proper
what area
jacket
of
today,
sheriff's
not
office
that
is
raincoat. A lot of people were
Court
talking about that in another chat.
And how
I
long
think
have you
it's a
been
courtroom where
on
you're
assignment?
meant to wear a jacket, and
For
because he
life.
didn't have his suit coat,
And tell us
he
what
had
are
to
some of
keep
your
on that
duties
raincoat.
within that assignment.
I supervise the deputies in 2
He does
county
not look
courtrooms
like a
and
Gavin to
also,
me. He looks more like Cheech
And
from Cheech and
are
Chong.
you familiar with the defendant in this particular case?
just through research that I've done on her, I don't have any personal knowledge.
And
It's a lot
what-
of gear he's
in
got on.
regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she would be charged with contempt of court, she still refused to attend those hearings.
After all these complaints
Those
about
kind of,
being,
when you combine all that, to me, it shows a propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
I would agree with all of that.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when
A long tablecloth like DB had.
she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains. So even if she's to make motion or movement,
Can't hear
it wouldn't
them.
make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Oh, wow.
Your Honor, I don't believe I have any further questions at this time.
Thank you.
Hate wearing bras, then you might want to check.
That is crazy. Oh, good Lord. We're going to get it together. Don't drop me any notes about premium. We're not there yet. We got to get monetized first. Yeah, that is crazy that they, yeah, well, she is charged with murder. But I think she means specifically only during this pretrial stuff, right? Because I thought at trial, you don't bring them out in visible shackles anyway, just like you don't bring them out in their jumps. It's not a jumpsuit, but you know what I mean? Which is why in the Daryl Brooks case, Judge Darrow was trying to get him to put on clothes, and he wasn't in there naked, but trying to put on street clothes, as they called it, so that the jury didn't see him that way, and he didn't get it at first. He was like, "Why? Everybody knows I'm in jail." Blah blah blah. So I feel like what she's asking for, the move around freely, is for these pretrial things. Although, where are you going, girl? Where do you need to move around freely? Like how Mr. Raincoat went all the way up. I don't think she should be that free. Like, no, shackled or not. I like in the well of the courtroom. You know what I mean? What do you think? Let me know.
Officer Logan.
I do.
Yeah.
Go ahead.
Uh-oh, he's got questions.
First off, in your inputs research that you've done on me, the
Wait, did she say incorrect?
domestic violence
Hold on. Oh my
case
God.
that I was charged with,
Did she say, and you're incorrect? She is always slinging dirt. Why? I don't know. I don't know why. You get more flies with honey. They want vinegar. She don't want no
Prior
flies.
to the jury coming in and being seated,
Uh-oh.
so they wouldn't see her walk in with restraints on.
Too far back.
And there's a panel in front of the defense table that prevents the jury from seeing that she's got.
Your inputs research that you've done on me.
Yeah, she did
jury from
say.
seeing that
Let's
she's
do the
got,
captions.
leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Logan?
I do.
Go ahead.
First off, in your inputs research that you've done on me, the
the captions they
domestic
kept it, but she said
case
incorrect.
that I was
research.
charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that.
You were charged.
Also,
you were just not
what
convicted.
3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date.
Girl.
In the almost 5 years that I've been here, I've never.
You haven't been there
I've never
almost 5
argued,
years.
I've never hesitated.
Object to the formal question, Your Honor.
Yeah,
I'm going to
because
sustain the objection.
she's
Ma'am, you have
testifying.
to ask one fact per question.
I am prepared to give her the dates.
yeah, he didn't even answer the date question yet. Okay. If there's silence, she's gonna fill
On
it.
September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
Okay.
And do you know what those were specifically for?
Court dates.
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or
Either
withdrawal?
one.
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At
court?
the jail, yes.
Who is?
I mean,
your
we can
contact,
pull
please? I've never missed a date.
the
This is
court
the
events
database
for
that I
those
got this
days.
information from.
Do you know when it was last updated?
It's, I don't know.
One of them is from 2021,
Okay,
ma'am.
so
It's been
do you know
updated
how-
since 2021.
I have never missed a court date.
Testifying,
to
objection,
the present date.
objection.
I don't know specifically what these 3 dates are for. In order for me to.
You guys
have
aren't gonna
supposedly,
You're
denied
testifying.
going. Do you know the name of the officers for each one? You do?
Yes.
Please.
Please.
For the September 15th, 2023,
Read them.
it is Corrections Officer Portia Hines,
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
That was just last
And
year.
if you would like, I can read.
Remember,
her
because then
comments
later
to
she
the
went
court.
off on Hobson because he waived her
Approximately
appearance.
midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
The
To
court
attend
hearing,
It doesn't
ma'am.
say specifically what your hearing is for.
Okay.
Second
Why
one,
would the officers in
it
the
would be Officer Christy Green.
And
why
what is
would they
this
know
date
what
for?
the hearing was for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's gonna be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K,
Greene.
yes,
Yes, green with an E on the
10/16/23.
end, ma'am.
yes.
Like
Okay.
the color.
And the third one is January 28, 2021. And the officer is Jasmine Scribner. Scribner.
What are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward in the Booking and Release Center.
There's one
transport
channel that
officer was
has some
notified.
of these notes
All
about like
proper
her not eating
notations
breakfast or
were
whatever.
made in the IMS.
They did it for you.
Okay.
But I don't remember
And
her
January 28th?
refusing. I mean, of course, you have to pull the right month.
Approximately 03:34 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were
God.
made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It
What
might,
is the
but I
IMS?
didn't take that information down.
Okay, so I'm trying to figure out I know all 3 corporals and the sergeant,
This
so
is not a question.
I've never refused court.
This-
There's no reason for me
Now,
to
argumentative
want to refuse
objection.
court.
I'm going to object this to ask and answer.
Yeah, okay. We'll go with that one for you. Oh, I saw a little bit of,
So the
well,
domestic
somewhere in
violence, the
here.
original was dropped. I was never charged with that.
Doesn't know what the stain means.
Object is to relevance, Your Honor.
Overruled.
Spectrum Internet offers the fastest.
Lord. Yeah, I did see that part on Brandy's.
Okay. It was
You just told me you
dropped.
could
You
answer
were
the
charged
question.
and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate. So they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
It said,
Argumentative.
object to the question.
Objection sustained.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons.
Objection. She's testifying.
I'm going to object this to the form of the question. It's not a question, it's a statement.
Sustained.
Yes.
Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently. So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
No one's asking you a
I
question,
understand
though.
your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is
Girl, your whole
do I-
education is suspect.
For the
Oh, wait, I didn't put it up on the
non-compliance,
screen.
I
Oh my God.
need to
Your
speak to
whole
the corporals and the
education
sergeant in order for that to
is
be remedied.
suspect.
And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
You
I
were
know that
charged.
the charges were dropped. I'm just saying that is in your history.
I understand, but I was never charged with it, correct?
You were charged.
It was dropped. The charges were dropped.
But it is not on my record.
It is on your record as
The rest is
charges.
on your record.
But the charge for the domestic violence is not on my record.
No,
Yes.
they were never
Object is to ask and answer, Your Honor.
Overruled.
The charge is
You were
on your
never
record.
convicted of
You were,
domestic
yes,
battery
that's it.
charge,
You weren't
but you were
convicted.
charged with it.
And the case was dropped.
Yes.
Yes, ma'am.
For the three supposed non-compliance that I have, I know that two of the
Somebody
officers
who
no
is
longer with the
not
Department
legally
of
versed.
Corrections,
She sure was
Orange County
racking
Corrections
up
Department.
charges for
So
George all the time.
I will need to speak to their
Weaponizing the police.
supervisors in order for me to have, I guess, this remedy. Is it
Your
a,
Honor, I'm going to object to the form of the question. This is a statement, question.
Objection is sustained.
I guess I will provide information to you for
That's a statement.
the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that
I
question
thought the
Thank
JC
you.
was getting
in the
her
way
pro
that it may be
se
asked.
document.
What do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Proof.
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
What?
Correct. I suppose if you have documentation to say that this
Do you have it
was
with
all
you?
fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is
What?
still part of your history. I can bring it up.
Right, but just to clarify and conclude, I was not ever charged with that.
You've asked that.
Again, I'm
You've
gonna
answered
object as to
that.
ask and answer.
Sustained.
You seem confused.
Okay, do I provide this information to you?
You can provide it to the state.
Okay.
Oh, the shade. He's like, I'm not giving you my contact information, ma'am. I heard about you.
Am I, in your opinion, a flight risk or detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraint.
And then what was the year, please, for the charge that was dropped with the domestic violence?
2018.
2018.
2018?
Right.
And it is now 2024.
Was that a question, ma'am? I have that video. I'm going to do a reaction to it.
And you're going solely off of what, the arrest affidavit?
Ma'am, just that you have the
What is it that
charge.
you're using to conclude due to this occurrence that was dropped that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
Right.
But what
Research,
specifically
evidence.
from that 2018 charge?
You tried to kill him?
Charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never
a man that was trying to get away.
dropped?
It was dropped. Doesn't
Asked
mean it
and
didn't happen.
answered.
Okay. I'll be working on the others with the corporals and the
Objection.
sergeant.
She makes
For
it
the
sound like a
supposed
threat. I'll be
non-compliance.
working with the.
Thank you for the dates, the information.
You're welcome.
Oh, Lord Jesus.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence
Like
occurrence
what?
that you are
It happened.
referencing and applying?
It's already been dropped. I'm just telling you what the history is.
Right.
And you can still apply it even though it's not been.
Correct. It's in
Yes.
the history.
Yeah.
Okay. Thank you for the information.
You're welcome.
I'm getting a lot of static in my
Any follow-ups,
headphones.
Steve?
Hopefully you guys don't hear it,
Thank
but
you, sir. Anything else, Steve?
Not from the state.
Okay.
it's not coming from me. She's mad. Oh, Miss Boone is big mad.
See Deputy Barnett here. Could you come up, sir?
Oh, you know what it is? It might be the whistling from my terrace door. Hopefully you guys can't hear it either way. It's whistling Dixie. And I hear static. Sorry, guys.
You should give Shelby the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
I wish it was afternoon.
And not your date of
To-
birth. Sorry, could you spell your name for the record?
The judge is over it already.
ETT.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm the deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff.
Is a electronic device that's wireless. It's box secured to the leg. It has 50,000 volts. It's able to be remotely.
That's what Daryl Brooks accused them of putting on.
How is
Ooh.
it fixed or placed on a person?
Can you guys
It's
imagine?
strapped along the calf.
You're shocked.
Either
Or-
way.
Can we talk when you're
And gives the ability to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
Oh.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be set.
I wouldn't even put one of those on my
Use
dogs. Like,
when
oof.
it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a two-step
And
process.
this doesn't go with
So
Sarah's
there's no way
narrative
for her
of,
to
I'm the
accidentally set it
victim,
off.
everyone's
It has
so
to be hit
prejudiced against
two
me,
separate
I'm
buttons. There's
so
no accidents.
innocent.
If it had to be used, it would cause a shock to the location on the calf, cause a great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation.
Ooh.
Are there any other protocols or standard operating procedures regarding the use of the stun belt? Other than what you've already identified?
Just to follow response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
Ooh.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it is at a level 3.
And what is a level 3?
Yeah, what
3
is
would
that?
be failing to follow the directions.
But how much
That
voltage?
we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Your Honor.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Of course.
Tell me, what is the title of this?
Stun
Cuff.
Cuff.
And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of the leg.
And
Achilles
is this
tendon.
something
Ooh.
that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts, we would take it off as court.
We would place it on you.
It takes a few moments besides signing the waiver and securing it to the leg.
This is
And it's
why
a
you
one-time
gotta
waiver?
follow the law.
Each day you're
Yeah.
welcome to sign the waiver.
Okay, and so there's no limit to how many times it can be put on and taken off, put on, taken off?
Well, there might be a
And it's a
limit
very
depending on what's going on.
simple process to apply.
Yes.
And
She
then-
sounds like she's game
Thank
for
you.
it.
Any follow-up?
Nothing to say.
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk,
You would be able to walk with the stun cuff freely, yes.
so hands free and able to walk.
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett?
Is she not able to walk right now?
Yes, thank you.
Wow.
She
Thank you,
walked
sir.
into the courtroom.
State any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option.
Oh my God. Is it an
Yes.
option for you
Okay.
to make?
Do I
Who's
need to
choosing?
supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I
It already
cannot
is an
answer that
actual
question
option.
Because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to
should
be
get a button
unrestrained with
that
that
just says that.
information?
Her speech
I think that
pattern.
would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
The paper is not going
If
to
I
be
may make it
restraining you,
clear
ma'am.
also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am
Oh.
asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank
Girl,
you for
why
that
didn't you
clarification.
write that in
Because
the
when I read your
motion?
You asked to be unshackled, to have
Move
freedom of
freely,
movement.
yes.
And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I
Right.
thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go
wrote
of having
a
no counsel
58-page
because
letter.
no questions were ever asked to me, just for the majority
your
of
responsibility
my
to clarify
motions and
what
letters and so on that I have
flip you are saying, yes.
supplied the court for more information to try to intervene and help. It's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
No, he's not going to ask you.
Generally, I don't know that I can answer that question because it may call for me providing you legal advice.
Right.
If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. By you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Why didn't you
state
that,
I review your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom.
Right.
All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the court.
Right. So there was no question to be asked.
You wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read.
Over and over and over again.
If you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know.
But why not?
So I was just trying to be transparent prior.
She got it right. She was trying to be transparent and failed, right? Why not be as specific as possible? She uses those $20 words and says nothing. Why not say during pretrial hearings, everything pre-trial, I would like to have my handcuffs removed so that I can write comfortably, right? And during trial, I would like to be unhandcuffed, unshackled, although it sounds like it's either going to be the shackles with the veneer on the front of their, which it sounds like their tables have the veneer, where like the Darrell Brooks one, they had to put not a curtain, but a drape. Is it a tablecloth? I think it's just a drape, like what you have at a wedding, so you're not looking at the bride's hoo-ha, assuming she has a short dress. But why not clearly state, and during a motion during trial, I would like to be X, Y, and Z, and she should have been able to look that up in the law library, right? Like too concise. Can you see my fingers over here? Too concise, like my 2 cents. Request instead of, I'm going to look at this really quick. Where's the motion to move around freely? How many? It's 4 pages. Matter of fact, let's just right quick look at this together. Can you guys see that? Uh-oh, where did you guys go? There you are. Okay, let me make that bigger. Let me stretch it out so you really can see it. Motion for defendant to lawfully receive, review. Oh no, that's not the right one. Hold on. Listen, I'm all share this stat loud and wrong. Here we go. Okay, let me make sure you can see it. Yes, here we go. Okay. Motion for defendant's reasonable freedom in movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Comes now Sarah Boone, Sarah Loon, pro se indigent defendant. Again, all these words. You could just put Sarah Boone defendant. Respectfully request, is it respectful? From the court to be unshackled, unhandcuffed, and allowed reasonable freedom and movement to function accordingly, equally, and comfortably while utilizing the courtroom. I wouldn't put utilizing the courtroom while defending myself, while defending my life. Something, if you're going to be dramatic in all the right places, ma'am. The defendant, I kid. The defendant must be able to write, reach, turn pages, pick up objects. Like what kind of objects besides a pen? Open documents, pass information. Who is she passing information to? See, that's why I said it sounded like she wanted to move around like the prosecutor was, right? Mr. Trenchcoat was able to get up, hand the USB drive to Mr. Lane, hand something to the judge. So that doesn't sound like just writing. Pass information, utilize laptop, all normal movement of the defendant's hands and as a whole to freely, properly, successfully accomplish any task needed for. With all due respect, unshackling, unhandcuffing doesn't guarantee successfully accomplishing any of those tasks. It doesn't. You could drop a pen, you could not be able to type, get glue on your laptop. I know I'm exaggerating. I'm exaggerating for effect and for a point. She's saying all these extra words that mean nothing. Prior to entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras and their operators, photographers, general public witnesses of the court, as well as vigilant armed deputies also in attendance. That sounds kind of sexy. Greatly diminishing all possible risk of flight or harm by the defendant while unshackled, unhandcuffed. Interesting. I mean, she did say that part, diminishing, but it does not eliminate all possible risk. It does diminish it. The defendant is simply requesting equal, comfortable, functional movement. Again, equal to whom? Equal to what? To achieve advancement in her forfeited right to counsel by the court. No, you, by your behavior, forfeited it. The court just called it like they saw it, like he saw it, which will greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. So she's saying in preparation for trial, which I would infer is all pre-trial hearings, right? Not at trial, which is what she just said. Is like, oh, I was trying to be transparent and whatever she said. The court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested respectfully. The correct understanding. If you want someone to correctly understand you, speak correctly, ma'am. Seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, and fairly. Achieve what in her criminal case rightfully, properly, and fairly? I really want to talk to her English teacher. Wherefore, Sarah Boone, pro se, indigent, defendant, respectfully requests to this honorable court, in conclusion, to be unshackled, unhandcuffed, and allowed reasonable freedom in movement to function equally, accordingly, and comfortably in the courtroom. And then her oath. Brandy was saying that this morning. That was funny. She had like a Daryl Brooks, I don't know what you call it. I guess a meme with it's like a box of oafs and it had his head on there, like the oatmeal what's his name? I can't remember the little oatmeal guy, but it was Daryl Brooks in there with the little hat on. So certificate of service, document has been hand delivered to the court. So that's what she delivered on Monday, 1 of 5 or 1 of 4. Well, 5, technically 2 of them were the same material. But that is bonkers, and that does not sound like what she is saying now, in my opinion. Okay, let's get back to this here, because baby, Sarah is master manipulator, masterful manipulator.
So
That
you would
word
know what
game.
it was that I was hopefully expecting. But first,
Go ahead.
it's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that?
Yes,
Just
what
so
do
we're
you
all on
mean?
the same field.
Right.
Shackled, as far as
Say
my
what you
understanding
mean.
is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled.
Yes or
not.
no? Is that what you're
So that,
seeking?
again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
You wouldn't know up
So you
forward
would be
if
seeking
it slapped you in the
to
head.
be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
Oh my God, these commercials.
But I don't know. I know from
Did she say
seeing
is
other
that
trials.
legal advice? Hold on, wait, let me go back. That's the courtroom procedure.
Handcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So that, again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials.
Not what you know. Is that what you're
the
asking?
State and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial.
You don't need to get up from your chair.
Is there anything else, ma'am, that you would like to tell me with regard to what you were seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I'm going to speed this up a little bit.
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings,
we
conferences,
see all your
whatever it is.
struggles.
For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now, just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and
it's not going to
equal
be comfortable,
opportunities just as
Sarah.
everyone else.
It's a murder trial.
Anything else you'd like to tell me?
If you get comfortable, I'm going to really be worried about you.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at the counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court? about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff.
Closing us. We ain't
I
talking
believe
about
that it is
this no
unfair that
more.
you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed.
That is
To be
oh my
able to
God.
progressively and actively participate properly and the same as others with just simply
Oh my
being able to
God.
write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a
No,
whole.
what are you gonna be bringing?
With
I'm
the same
scared.
equal level as
Not a
anyone in the courtroom
suitcase.
would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Barney identified, Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free.
I have spurs that
the
jingle
legs are in
jangle.
restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. J?
No, you're just address all the concerns, which is the court's line.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first degree murder. And there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence.
Ooh.
This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not use its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less
So
prejudicial
she's gonna
or
get the
viable.
stun cuff.
There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, and especially in light of the defendant's pro se status. In that case, we had a firearm. It was first degree murder. Here we have second degree murder. The incident is identified by
is the suitcase going to be in the courtroom? Because we know that's dangerous.
Non-compliance in jail for reportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first.
With the stun cuff.
Any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward.
No, we defer to the court and the sheriff's office, who's in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury.
2 out of 2.
Thank you. All right, so ma'am,
gotten 2 of her motions,
and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table. Okay, you may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the Stun cuff, as identified by Sergeant Barnett, will be affixed to you, and you'll have to sign that waiver. Do you have any questions for me, ma'am?
And for sitting here in the council's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at council's table with that.
Then
As
why
you walk
did she
without your
mention the
hamstrings.
shackles
Okay, so I would
being
be
unshackled?
Correct.
Yes, thank you.
All right.
She mentioned being unshackled several times in her motion. Why? If she's not currently
TikTok keeps trying to tell me
shackled.
that I have secretly wavy hair. I'm gonna prove them wrong.
Are they, girl?
Oh my god, they're right. I started using custom hair care from Pro.
Goodness gracious. Her. I just want to go back really fast to this other tab. So here we go. First of all, am I unmuted? Yes, I am. Okay. I'm unmuted, but you can't see this screen. Here we go. So let's just count unshackled. Unshackled once, twice. Yes, that is my tear store, Whistling Dixie. Twice. Oh, maybe she only said it twice, but why say it even once if you're not actually shackled? Let's do that again. Unshackled, unshackled. What is that waist thing called, though, if she's not shackled? Or is that part of shackling? Well, she said maybe she means her feet are not shackled. But yeah, what's that chain around her waist for? Okay. Oh no, here's another unshackled. So that's 3 times. Let me just go back through here. Yeah, so she mentions it 3 times. However, if you're haven't been shackled, why you think going in? I don't know. I don't understand her. But also, I was thinking, what's that guy's name who had the stick up hair who murdered his wife and his special needs daughter? Lonnie, something. He was walking around because I remember he was in that horrible opening statement hollering like he didn't have good sense. He was walking around the well. So you guys know who I'm talking about? That was in Florida. So yeah, good for her. She got 2 of her motions. Well, they were going to change the address no matter what, but let's give credit where credit is due. She technically got that motion granted, and then she got this one granted. So let's see how the rest of this goes. We're at we have 15 minutes left, so let's get through this. Okay. Good on her for asking then. They won't see it. So she'll have with the belly chains. Okay. So she'll have the stun cuff and ankle shackles in front of the jury. Woo, she's gonna squeeze in the question. Who's gonna get her trial clothing?
with you, ma'am, after our
shit,
hearing.
you guys
So
didn't
she
hear.
can
Hold on, let me
facilitate
go back.
clothing for you, including pants and motions moving forward.
No, we defer to the court and the sheriff's office, who's in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so now, the court's gonna grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, the only thing you have is your handcuffs.
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Uh-oh. That's the part where... So maybe it was prudent because they're about to correct that.
Item I have on, yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes, sir.
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with belly chains and all that. We can take those off.
In advance. Yeah, I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're gonna have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to?
It is under your clothing, as Sergeant Barnett identified.
Wait, I thought they
I
said
have a
shackled
representative
and
from the
the
public
stun
defender's
cuff.
office who I've asked to be here. She's gonna have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
What if she
Yes.
wants to wear a
Okay.
skirt and some cute boots?
Does that clarify for you, Steve?
I was wondering about her
I saw
clothing.
them and I thought that I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're gonna be able to wander wherever you want in the courtroom. There's gonna be spots where you're gonna be able to go to. You're not gonna be able to walk all the way up to witnesses. You're not gonna be able to walk everywhere that you want. There's gonna be places that you're gonna have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm gonna give the same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was gonna, either you could do it or I was gonna have the deputies do it. So.
I think have the
ma'am, I
deputies
envision
do it
that
for
because
both
you're gonna be able
sides,
to
so
move
it
about,
doesn't look weird.
freely, and our jurors are not gonna know that you have any restraints on you, and they're not gonna be able to see the stun cuff. You can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm gonna ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness.
I feel like she
Okay?
should have the
All right.
shackles
Do you have any
on
questions
in the
about the court's
stun
ruling
cuff.
or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand, and you said that it would be clarified greater once we get closer to that date. But I would like to ask,
Be
please,
clarified
when the
further.
time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy?
Betty.
Or is it specifically whoever's the closest and can do it faster?
So what I'm gonna do, ma'am, is I have spoken with the sheriff's office. I'm gonna endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal, be seated closer to you. So that if you have a document that you wanna bring to a witness's attention or ask them questions about it,
Don't
you can
tell her
hand it to
for her
that dedicated
disposal.
deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
When
Okay,
is
so
she
your
gonna
motion
be
is granted
handing
for the reasons
witnesses?
stated on the record. State anything to clarify?
No, you're not.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024. A representative from the Orange County Jail sent email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of a laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today.
They want those receipts. When and for how long?
Is there anything else stated?
Does she have that laptop?
No, Your Honor.
Did you guys
Ma'am,
notice
is
the
there anything
state
else that you'd like to bring to my
didn't
attention?
file any
Yes, please.
motions?
Yes, ma'am.
In regards to the status report you were just speaking about regarding them providing me with a laptop each day, what is your definition of entries?
The protocol, ma'am, that was read.
You don't have
that
to
you were given a
enter.
hard copy of.
You don't have to enter
Monday.
anything.
It was
You
also
don't have to
mailed
create
you
an
on,
entry.
I believe, the 30th, at the appropriate PO box for legal mail. The protocol identifies entries that are in information management system at the jail for when the laptop is released to you and then returned.
Oh,
Okay, so it's
IMS.
simply just an entry by the officer stating that they gave it to me and it was returned.
Here's how auto mechanics remove car
So IMS is, oh my God, I forgot it. Intra or inmate management system. So that must be like where it's documented, like she refused her breakfast or whatever else. She refused to go to the hearing. They document all that. Like what we saw from Donna Adelson and her spoon drama, right? I think that's True Lifestyles that I believe her name is Susan, the True Lifestyles channel. Didn't want the spoon, argued about the spoon, didn't take her food. That was Donna. And I know I've seen it somewhere. I'm gonna have to do a FOIA request so I can get it my little hands on. I don't know if I want all 4 years on there. Yeah, it is almost 4.5. What's today? It's almost it'll be 4.5 years for her, closer to the end of this month on the 25th that she's been in jail. I don't know if I need all 4 years, 5 months, and however many days that is, but I'm curious. I know she wasn't eating breakfast, but I did not see that she refused court dates, which is gonna be used against her later if she ever tries to, like, make us think about, Hobson waiving her right, because she was like, "I haven't seen the waiver," but ma'am, there's 3 times that you didn't go, so you're being disingenuous when you say you would never miss a court date because clearly you have, and that's documented and been documented. Like, why would the deputies lie about that? It seems a little strange.
In the protocol.
Okay, and my concern was they're not stating what it was that I looked at for how long and
I don't know that
anything.
they're going to record that information on the
No,
protocol.
how would they know?
It's just simply when it's checked
Well,
out and
they might
returned
have
under
put
the
these
protocol.
somewhere else.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence, and I know that that was something pending in regards to the media being.
The physical evidence were set to review that here in court on September 3rd at 9
Yeah,
o'clock in the morning.
he was going
And
to
that was
follow up
identified in
about
the order from the
right.
5th mail, which you said that you got a copy of through the
That was
mail.
already talked about.
That's at paragraph
He just
5.
needs to
State's
decide if
physical
the
evidence will be
media is
reviewed
gonna
with
be
the
there.
state and the defendant on September 3, 2024 at 9 a.m. in courtroom 12A
Not-
in Orange County Courthouse and the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
Yes, ma'am. I pulled the case law on it. I need to
Again,
review that case law,
lack
see if
of
an evidentiary
clarity.
hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to
They have
utilize
space
that
to
hearing
store it,
for.
but where will she be viewing it in private?
I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue
Next Wednesday.
based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th.
That's correct.
Yes.
And what is the time, please?
1:30 in the afternoon.
1:30.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
No.
Sure. I don't see any problems. The Miami Herald decision, I don't know the citation off the top of my head, but I don't have a problem. I have no problem.
Miami Herald.
Sure. Man, what I'll do is
We'll
I'm
have
going
to
to prepare
look that
another
up,
work.
you guys.
I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank
And
you.
that will be heard on August 14th at 1:30, in addition to the status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing of good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state
evidence, the digital evidence only.
of the 2 USB drives from Mr. Lane?
No,
No.
ma'am, the USB
Oh my
drive that
God.
Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct.
Yes.
So your objections to the digital discovery will be
Well,
due no
you don't
later
have
than
to.
August
You
23rd.
have, if you want to write objections, you
And I will
have
put this all in
to.
order for you as well, ma'am.
Thank you.
I believe that addresses all of the
Woohoo!
court's matters that were teed up for today. State, do you have anything else?
No, no.
Ma'am, is there anything else?
I do have this. I made a copy of it for you this letter that I supplied to Captain Di Giovanni upon her return, knowing what I am requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone.
You don't
I have,
need internet.
I'm trying
The
to utilize
judge
the
told you
classroom
he
that is
didn't
in
know
our
there
dorm.
was
I'm
internet.
trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was
Isn't
to
that
keep
in
it
the
at my
protocol?
bunk in my locked drawer.
They said they were not
along
going to
with,
keep it at the drawer.
Of course, the internet, if I could be supplied earphones and headphones for listening and
I
word
think she
program,
does
just
need
simply to be able to
headphones.
type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives.
Yeah, just
and
for you to look at the evidence.
As I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Whew. Did you get that, Judge?
Now, you can give your letter to the deputy. We will file that in the court file.
It means we can read it on Monday.
Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain Giovanni was returning on August the 12th from a vacation, and we were
Right.
endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on media request or
Woohoo too soon.
prevent media
guys.
from being at the September 3rd
Woohoo too soon.
discovery
Discovery, yeah.
hearing.
Come on.
Will address your concerns as identified in this letter and have a representative from the jail, be it Captain Giovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
Oh, yeah.
That is, I know that I have a lot of my case details that are already online.
What are
For
you
me
opposed
to
to?
be recorded, inspecting and testing and photographing, I believe that is my business only. And one
What are you going to be
privacy that I
photographing,
should be
ma'am?
able to
What?
maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you
Praise
all on August
Jesus.
15th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of the mail. It was already mailed. Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the
I
deputy and
wish
provide
I
to
had
you.
like
This is the pro se
streamers
packet
on here.
that the JAC attorney
Gotta
made
up my
reference to
game
on
here.
our hearing on August 5.
Yes,
I
thank
would've
you.
popped
And then
some
also the
champagne
public
for
defender's
that
office,
one.
you said would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. They will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail. Thank you.
Peace out. Oh wait, he's walking out. Let's just look. I'm gonna mute it though. That, I mean, I think that was a successful day in court, right? Oh, they were. I feel like okay. Let me get these people out of my ear. Number one. Um, although I am kind of interested in the saggy neck solution. So overall, as painful as it was, I feel like progress was made and she sufficiently moved her case forward. Um, Sufficiently, not successfully, like all the adjectives. I think she swallowed like an adjective book, not a whole dictionary, just a book about adjectives. Yeah, I think overall she got what she wanted. I feel like she belabored the mailing issue, right? Especially when the judge clarified only one piece of mail went there. She sent two separate letters or two separate motions, however you want to frame it. Some of this stuff is just um repetitive. I mean, to state the obvious, like she's again asking the judge about the internet. Are you filing a motion about it, ma'am? Or are you just bitching? Because he told you he didn't know if there was one, and well, whatever. I just don't. What is she trying to do on the internet? And I have questions. I have so many questions. If she is granted internet access, is she also going to be given a jail email? Because inmate communications are meant to be monitored, right? So she can't just have unfettered access to the world because she could be plotting to blow up the whatever jail she's in. You know what I mean? So do they give inmates? I know some places do, some places don't. So I'm just wondering if anybody knows about this Orange County situation. Let me know. And then I'm glad they addressed the clothes because I have been thinking about that. Like, what is she gonna wear? And only reason I was thinking in all the videos I've seen her in, she's super casual. So I don't think she has like any like. Well, I don't even know where her stuff went because she got evicted. Did they just pack it all up and put it in storage? I don't know what the law is down there for evictions, but she had either like jeans like she did for the interrogation or shorts and little t-shirts, right? So she hadn't had a job 2 years prior to her arrest. So what, 2018? So maybe Brian meant 2017, like 2018 and 2019, she didn't have a job. She got arrested in February. She got arrested February 25th of 2020. So I'm glad they're gonna get her some clothes. Hopefully they give her some hair coloring recommendations. I'm guessing they have dye in jail, and I'm one to talk, right? But mine is intentional, unlike hers. Her hair looks really inky with whatever dye she is using. I know she used to have highlights. I even saw a video with her with like blonde hair in the front. It's making her look severe, right? So listen, I haven't switched sides, but I'm just saying as a defendant, you want to look a little softer, right? Especially because like her oral presentation, like how she puts her mouth together and everything is super aggressive. And just then she sits there like a frog and like, I can't make my neck do what she's doing, but it's like, girl, soften up. And I know she has it in her because I've seen the videos of her being like happy, giggly, hey babe, or whatever. So like lighten that up a bit and not look so severe and not look so angry. Like, why you mad? Ain't nobody put you in the suitcases. Why you mad? Please. So yeah, we'll see. Anyway, this is interesting. So I will next Wednesday, you and me, we got a date in the courtroom. In the meantime, I'm going to endeavor to create some reactions on the other videos with Sarah in it. The one where she got arrested, where she told, which she mentioned during her investigation of like, I got arrested because our stories were different. Oh, look, it did a thumbs up. Can you guys see that? Oh, that must be a MacBook thing. Oh, no, it's not going to do it. I got to figure out how to do champagne. Boop, boop. Anyway, I'm so easily distracted. Yeah, so where she said, I got arrested because our stories were different. The one that actually, I'm pointing because my TV is over there. the one that we just saw together where Cheech was talking about it was a violent act of strangulation. That one, I've seen the video for that. And then I think that's the one where she has the super blonde hair. And then there's another one where she called the police in the morning on George. He wasn't there, saying he stole her credit card. He's not there, so they can't arrest him. Then they go to his mom's house to look for him, and she's like, he's at work. And she says the lady, she doesn't even say her name, God bless her. She's like, the lady took his ID. That's the only reason why he was over there, right? And so then somehow I don't want to say she lured him, but I kind of want to say she lured him back to her apartment later. So then the police show up again and they arrest him. Oh, it did it again. There we go. I don't know if you guys can see that. I like that. And they arrest him, and she's pretending like she had nothing to do with it. And it was like, oh, George, I'll do whatever it takes to get you out. How about not calling? How about giving him his ID back? How about, why did you call about your credit card like he was out charging it up? In my mind, and again, I wasn't there. These are my 2 cents. That's why you're here. She took his ID, and he, in return, took her credit card. Now, is it right? I'm not saying that. Clearly, they had some Arrested Development shit going on in their relationship. But I don't think he took it to use it. And she never says, oh, yeah, he's out charging up my card. I think he took it as a placeholder so that he, collateral, so that he could eventually get his ID back. That was in, I want to say, I think that was 2016, 2017. They had only been together a little over a year. He didn't know how nutty she was yet. Either way, like that, I would have left without my ID. DMV passing out IDs all day, every day. You know what I'm saying? Well, Monday through Friday. But I wouldn't have gone back for that ID. I would have left. And then there's an interview with the brother where he's saying every time George tried to leave Sarah, she would beg for him to come back, and she would play little games like with the ID and the whatnot. So we'll get into those. Hopefully I'll have those up for you guys before next Wednesday when we are back in court with whoever is going to help dress her. I hope they have some style. All right. Talk to you guys later, my lovelies. Toodles. Bye. Thanks for hanging out. Like, comment, subscribe. We're building up our subscribers. I appreciate you. Thank you.